Good morning. The Hearing Board of the South Coast Air Quality Management District is in session. Today is Wednesday, January 8th, 2020. The time is 9:00 a.m., and we are meeting in the Hearing Board room in Diamond Bar. We have one matter on the calendar for today, and that is SNC Oil Company, Inc. and JP Resources, case number 6165-1 for a regular variance. And who is representing SNC Oil this morning?
Ivan Tether of Tether Law.
Good morning, Mr. Tether.
Good morning. Thank you.
And who is representing the executive officer?
Mary Reichert on behalf of the executive officer.
Thank you, Ms. Reichert. We did not actually complete hearing this matter. We did hear on interim variance relief request. We did hear the good cause, and with that, we had a number of exhibits that we had marked. We had a fair amount of testimony that had been given. Dr. Bernstein was not present. However, Dr. Bernstein has reviewed the webcast, and he has received those exhibits. Is that correct, Dr. Bernstein?
Yes, Madam Chair.
Okay. So what we could do is incorporate what we did receive in today's hearing. However, I do believe that we should, I don't know that we fully heard everything, and I would like to at least briefly go back over some of what we did hear. Does that make sense to the parties, Mr.
It does, and I appreciate the incorporation of the prior exhibits and testimony. I will have 3 new exhibits that cover basic descriptions of the rules that we request relief from, and the steps that Doug Williams, who is the owner of SNC Oil Company, has been taking, including contacting vendors for permanent systems and such as that.
Thank you. And at the appropriate time, I assume in your opening, if you could also clarify, I know we have another petition that we'll be hearing in February with regard to other facilities, and at the last hearing, there was a letter asking to incorporate additional facilities into this petition request. So if we can make sure we're on the same page as to what this request will cover today.
Yes, I'm trying to, in deference to the fact that they're separate petitions, limit the testimony to today's coverage for the 3 leases. However, Ms. Reichert and I spoke very briefly yesterday about the fact that physical steps that SNC Oil Company is taking are also being taken simultaneously for the Moore and Douglas leases, which are the subject of the 6561-2 case and petition.
Okay, so when we get to that matter on the 5th of February, we could consider incorporating some of the evidence today if the parties so wish.
I think that would be helpful. I'm hopeful also that we'll have more to tell you. For example, Mr. Williams has contacted 5 vendors of permanent vapor recovery systems and gotten bids from 3. And this, we'll have more to tell a month from now.
Okay. And Ms. Reichert, as far as how we plan to conduct the hearing today, does that make sense to the executive officer as well?
Yes,
Okay.
Thank you.
Then with that, I'm going to begin, Mr. Tether, with your opening.
Thank you. And good morning, Chair Prusek and members of the hearing board. Thanks for the opportunity to come before you today. SNC Oil Company produces crude oil, and we petitioned for variance coverage for 3 of its facilities. District ID 64093, known as the Pauley lease, ID 45882, known as the Whitney Barnes lease, and ID 122974, known as the Barnes Bush lease. The Whitney Barnes lease is now in compliance by virtue of a district-permitted rental thermal oxidizer, although I will be making reference to one equipment description in the permit. As you've heard me say before, whenever crude oil is produced, gas is also produced, and AQMD rules appropriately require that the gas be dealt with and not be vented to the atmosphere. Since early 1979, SNC has relied effectively on sending its produced gas to Signal Hill Petroleum, or its predecessor. In October, Signal Hill stopped taking SNC's produced gas because Signal Hill's turbine used to convert the gas to electricity broke down. S&C stopped producing oil. As soon as the turbine was repaired on or about November 7th, 2019, Signal Hill resumed taking S&C's produced gas, and they were able to return to this long-term method of vapor recovery, but it was very brief because on Thursday, November 14th, Signal Hill notified S&C that certain of their wells, in fact all the ones we're talking about today, would be shut in the next day, Friday, November 15th. S&C shut down its oil production before vapor recovery stopped. But on November 18th, Signal Hill informed S&C that its wells would continue to be shut in, and it soon became clear that after 40 years, S&C will no longer be able to send its produced gas to Signal Hill. This petition was filed on November 20th, 2019. Despite the fact that S&C is maintaining a shutdown of its production at all 3 leases that are before you today, there's still a potential for small amounts of vapor emissions from process and storage tanks. S&C has been diligent in responding to this situation. For its largest lease, Whitney Barnes, S&C installed and has been operating since November 27 a district-permitted various locations thermal oxidizer, which returned that lease to both compliance and production. For the 2 smaller leases, Barnes-Bush and Pauley, S&C removed most of the oil from the tanks. To deal with any residual tank emissions, S&C has purchased and will soon install 3 horsepower electric motor-driven compressors that will automatically pump tank vapors down well casings in anticipation of warmer days, or when the pressures in the tank start to increase such that they could potentially release.
Yes.
Oh, of course. S&C is going to put in new systems at the 2 leases under this petition that remain in noncompliance. They remain in noncompliance because there's a potential that the tanks will release some vapors. There will be hooked up between the tanks and certain well casings, lines and a compressor and an automatic switch that is pressure actuated. And if the pressure in the tanks, any tank, starts to approach or even come close to a level that would trigger a release from a valve at the top of the tank or elsewhere, a pressure release device that's used to avoid tank collapsing, then some of the gas in the tank will be routed into the well casing. The well casings that will be used include wells that are 4,000 feet deep, so there's ample capacity for the well casings to take the excess gas. And then as the night cools or whenever, as the pressure drops, it's important that gas go back into the tank to maintain a certain pressure, again to keep the well from the tank from collapsing. So that will go back and forth, and we expect actually that will eliminate any potential for venting. We're saying that we expect it to substantially reduce or eliminate, but we really think it will eliminate that potential. And this will deal with the situation for the time being until S&C can either find a temporary solution or finally identify, get permits for, and install permanent vapor recovery on these at these leases. Is that clear? It took me a while to understand it. Okay. So this approach, as I said, will greatly reduce or potentially eliminate venting of tank vapors, and S&C anticipates completing this mitigation step on or before January 29th, which is one of the conditions that Ms. Reichert, or this district, and I have agreed to. With production shut in and use of the electric compressors, mitigation of excess emissions is substantial. Before operation of the compressor vapor collection system, we calculated for the poly lease less than 3.3 pounds per day of VOCs and less than 0.1 pounds per day of benzene. Again, before operation of the system I described, we calculated the Barnes Bush lease to have less than 6 pounds per day of VOCs and less than 0.1 pounds per day of benzene. To provide permanent vapor recovery and return all 3 leases to full compliance for the long term, S&C or Doug Williams has taken the following steps. Starting on November 19, 2019, which was the day before we filed this petition, S&C contacted 5 vendors of vapor recovery and control systems. They've met with 4 of these vendors. They've gotten bid proposals from 3 of these vendors, Ship and Shore Environmental, Clean Energy Solutions, and Baker Furnace. There was some delay between initial contact and receiving bids because of the holidays. So we expect additional bid proposals within the next few days. As soon as it identifies the best bid proposal, S&C will file applications for permits to construct, to install permanent vapor recovery and control systems for all 3 leases. We're estimating that identifying the best bid proposal will take until the end of January, that permitting without CEQA analysis, and these are small leases, so we don't anticipate that requirement, will take 4 to 5 months, maybe less, and that obtaining the system from the chosen vendor will require an additional 2 to 3 months, and that installation will require less than 1 month. S&C has a very strong incentive because until there is either temporary or permanent vapor recovery at these leases, they won't be producing oil. And they're losing, I think, about $3,500 a day in revenue from not producing the small Pauley and Barnes Bush leases. So we're going to be requesting a regular variance for 10 months, but we'll get into that a little more as testimony is presented. Thank you.
Thank you. Before, Ms. Reichart, before you begin your opening, we're going to mark the proposed regular variance conditions that we received, 1 page, as Exhibit A, as an apple. And Ms. Reichart, your opening.
Thank you. Subject to the testimony presented here today and compliance with the proposed conditions, the district is not opposed to the granting of this variance. Thank you.
I'm sorry.
Subject to compliance with the proposed conditions, the district, Exhibit A, the district is not opposed to the granting of the variance. Okay. I'm sorry?
Should there be in compliance with Exhibit A, that you don't oppose?
Correct.
But if you're not, you will.
Well, I mean, if changes need to be made, I may stipulate to those, but yeah.
Okay. Before we begin, I'm going to ask anyone who wishes to testify today to please rise to be sworn in. Thank you. Mr. Tether, you may present your first witness.
Thank you. Before I do that, I will present you with the 3 exhibits I referenced.
Okay, let's do that. And we're going to be starting with number 7. So I'll identify which ones will be marked as which numbers once we receive them. While we get those sorted, we'll take a moment to review those proposed variance conditions.
Should I describe them? Or?
Yeah, we could do that. Why don't you do that?
Well, just to let you know what's coming, Exhibit 7 is just a kind of a little crib sheet that I made for myself because I kept confusing the IDs and the names and the addresses. So it tells you the lease names, the IDs, the addresses, how many wells, and the status. It's a very short exhibit. Exhibit 8 is 2 pages. Again, it refers to each lease, and it talks about the excess emissions and the applicable rules. And that's, for us, I thought it would be helpful to present those in an exhibit, the applicable rules and permit conditions, and perhaps permit equipment descriptions from which we seek variance relief. Exhibit 9 is a timeline, an Excel spreadsheet, which sets out kind of how this situation arose. When Signal Hill first notified S&C that they would not be able to take their gas. Several NOVs that have been issued might have been avoided if we'd come in a little earlier, but that's not chosen at the time. And also the specific context that Mr. Williams has made to various vendors. And we hope that those are helpful.
Thank you. So we will mark each exhibit as has already been marked, 7, 8, and 9, and as described by Mr. Tether. Thank you, Mr. Tether.
You're welcome. Yes, I'd like to proceed with introducing my first witness, Mr. Douglas Williams. Mr. Williams, could you please spell your name for the record?
Douglas Williams.
Mr. Williams, have you taken the oath?
Yes, sir.
And how does your work relate to the case before the board today?
I'm the owner of S&C Oil Company, a small independent oil producer in Southern California.
Thank you. I want to provide a foundation for the exhibits. Turning your attention, Mr. Williams, to exhibit number 7.
Yes.
Do you see that? And you have looked at this before, I believe. Have you looked at this before?
Yes, I have.
Do you believe it to be true and correct to the best of your knowledge?
I do.
Turning now to exhibit 8. Have you looked at this before?
Yes, sir.
Do you believe it to be true and correct to the best of your knowledge?
I do.
Thank you. Now turning to exhibit 9, the timeline. Did you participate in the preparation of this timeline?
I did.
What does it set out?
The steps we've taken to remedy the problem we have with Signal Hill Petroleum not taking our produced gas and vapors from the tanks any longer.
Thank you. And do you believe that it's true and correct to the best of your knowledge?
I do.
Okay, thank you. And has the board had sufficient time to look at the exhibits?
Do you wish to go through any of them as part of testimony?
They will be referred to in testimony.
Okay, then we can
Except
do it as you go
The first
along.
one, as I said, is kind of a crib sheet to keep the names of the leases and the numbers and their addresses
And that is
straight.
very helpful and appreciated by the board.
Thank you. Mr. Williams, are S&C's production leases, the Pauley lease, the Whitney Barnes lease, and the Barnes-Bush lease out of compliance, even though production was stopped before Signal Hill stopped taking their produced gas?
Yes, they are. We've discontinued oil production at all 3 leases, and then we obtained the thermal oxidizer for the Whitney Barnes lease, facility 45882. So that has permitted equipment now operating that's taking the gas and burning it through a oxidizer. We have a permit on that for 12 months from, I assume, when we started using that equipment. The emissions from the Pauley and the Barnes-Bush leases have been reduced by taking oil from the tanks and discontinuing the production from those wells.
Is there a potential for emissions from those leases?
Yes, as the tanks heat, there's some discharge possible, that if it exceeds the vapor control valves, there's a control valve on the tank as well as hatches. So it is possible that there is some escape.
Thank you. Now, are you going to do anything to reduce or eliminate that potential venting?
Yes, so we've purchased compressors, vapor pumps, and we're installing those as we speak. I have 2 electricians and a roustabout working on the plumbing. So we're working on those as we speak.
And could you describe the compressors?
Yes, what the compressor is going to do, Signal Hill was taking the vapors. They had a vacuum line. So basically, they provided vacuum service to all over Long Beach Signal Hill area in the field. So they would pull the vapors from the tanks and the wells, and they would handle the gas through the city sales line, or they would burn it in their generator. They've had problems with that generator, so they're no longer taking our gas due to the high BTU content and their arrangement with the provider of the generator. The sales line, I think they have as much gas as they can handle on their own right now, so they're not able to take that gas. So what we're going to do, and has actually someone else in the field is doing, we're installing these compressors, and it'll provide a vacuum, as was provided previously by Signal Hill Petroleum. And what will happen is that vapors from the tanks only will be put in the wellbore of the casing from the well, and that's basically a pipe in the ground that's 4,000 to 10,000 feet deep, and it will compress the gas into that reservoir, big pipe, and it will act as normal. Our existing valving has a gauge on it, so as the pressure builds up, it opens a valve electrically, and the vapors are pulled off with that vacuum. When the pressure is low, as the case when the tank is cooling, the pressure will bleed back to the tank through a separate valve and separate gauge. So basically, you'll have a closed system where the compressor is putting the gas into the wellbore and then coming back to the tank when it senses that pressure is low.
And why is that important? Now, first, I want what drives the compressor?
It's 3 horsepower is what we're doing in the electric motor.
Electric.
They're electric, yes.
Thank you. And why is it important to put gas back into the tank?
Well, you keep the oxygen out of the tank. It's kind of a blanketing system, so you don't have a explosive condition. Also, you don't want to pull the vapors too quickly for truck loading and things like that. It replaces that gas. Also, the water pumps, there's quite a bit of water that's produced, so when the water is taken out of the tanks and pumped out, you'll have a creative vacuum. So,
But is there any truck loading or production at this time?
no, not at the
thank
Moore
you.
and Douglas, no.
Is the
I'm sorry, the Paulian.
I think could you describe tank integrity in terms of the pressure within the tank and how that is
sure.
also a factor?
The control devices on the tank for design of the tank are set at about 4 ounces of water pressure, so they're very, very low. We can set our solenoid valves, the electrics, that operate that. there's a little gauge on them, and we can set that to under 1 inch of water, and so that there's no emissions from those devices that protect the tank.
So you would be maintaining tank pressure well below a pressure release release device venting.
Yes, and that's the way everything had worked previously when the tanks were vented to Signal Hill Petroleum.
Thank you. Now, this is a longer question, and, well, I'll let you say what it is, but could you identify, please, the rules and conditions or even equipment descriptions that are potentially violated?
Yes, that is spelled out in Exhibit 8. For the poly facility ID 64093, Rule 203, and permit conditions 2, 3, and 5 are currently not in compliance. Number 3 is something that we'll have to change. We don't expect we'll ever be back into the Signal Hill gas line.
And what does number 3 say?
Number 3, while oil production is shut in, tanks are apparently still required to be vented to the gas sales line, which is in full use. That's a stipulation of our permit.
Yeah, and that's no longer available.
That's correct.
Okay, please continue.
Also Rule 463.
You could use the C also.
Oh, I'm sorry. 463C, Rule 1148D8, Rule 1173D1B, and permit equipment descriptions.
What does that say for the poly lease permit?
Yeah, the permit equipment goes on to say, I'm sorry, connected to gas sale lines that gas sale we're no longer connected to.
Okay,
We are physically disconnected from Signal Hill Petroleum.
thank you. And the next one, Barnes Bush.
Yeah, Barnes Bush Facility ID 122974, Rule 203B, Rule 463C, Rule 1148 1.1D8, Rule 1173D1B, in addition to permit descriptions, again, connected to the vacuum sales line. Yeah.
Back to 203B, is there a condition that's potentially violated?
Okay, yes. It says it's specifically connected to a vapor recovery system.
And what number is that condition?
That's under the conditions. That's a number, well, that was under the Rule 203B.
And condition,
And condition number 2.
thank you. And those permit equipment descriptions, which numbers were those?
For the Barnes Bush, it's number 1 and 2.
Thank you. Now, for Whitney Barnes, could you identify that and mention the compliance status and whether that still requires any variance relief?
Sure. We're in compliance as far as the venting and all those kind of issues at that site. We do have a description, permit equipment description number 6 states that also, again, we need to be discharging to a gas sales line, which is no longer available.
Thank you. Is there a regular maintenance or inspection schedule for equipment in either of the 2 production leases that remain in noncompliance?
No, we don't have any maintenance. We were reliant on Signal Hill's vapor recovery line.
So it's not your equipment?
That's correct.
Now, are either of the 2 production leases that remain in noncompliance, have they currently or within the last 6 months been under variance coverage?
No, they have not.
Has the district issued any notices of violation concerning any of these 3 leases within the past year?
Yes. November 5th, facility ID 45882 with a Whitney Barnes lease was given an NOV number 66532 For rule violations 1148D8, 463C3, and 203B.
Thank
Poly,
you.
yeah, Poly lease, facility ID 64093. District inspector issued 6654 on December 12th for a rule violation 1148.1D8. The production was shut down before the NOV was issued, but there were potential emissions from the tank. I guess some venting was observed. Barnes Bush, facility 122974, NOV number 66543 on December 12th, again for 1148.1D8 and for the same emissions and not being connected to a vapor recovery.
Thank you. Has S&C received any complaints from the public regarding any of the 3 leases within the last 6 months?
No, we have not.
Is this violation beyond S&C's reasonable control?
Yes, it is. We were reliant for years on Signal Hill Petroleum's vapor line or vacuum recovery line.
Okay. And is that beyond your reasonable control?
It is, yes.
Yeah. Now, are you, have you been able to return any of the leases to, I think you've already covered that. You've already covered that Whitney Barnes is returned and you're going to install the electric motor-driven compressors, so. Okay. So what would be the harm if S&C was required immediately to comply, so as to not need a variance?
Well, really the only other thing to do is clean and rinse all the tanks. It's quite a process to do that. I think it would be a larger nuisance and more emissions than had the tanks sitting there, stagnant. We are including, we're putting in the vapor recovery pumps, the vacuum pumps, as we speak. Like I mentioned before, we have electricians on site now, as well as roustabouts doing the plumbing work. Those should be installed within the 2-week period that we're talking about for relief.
And what will that do to the potential for emissions from the tanks?
I would expect it would eliminate the emissions. We'll be back operating. We won't be operating the wells. It will just be the emissions that would be venting off of any residual oil and sludge that's in the tank.
Do you have an incentive to get back to compliance?
Yes, absolutely. We have an incentive. We're losing the money you mentioned, approximately $3,500 a day. That's gross revenue. In addition, we have been getting calls from royalty owners. We pay approximately 14% of our gross to royalty owners, 6 to 14%. In addition, the cities get 80 cents a barrel on an oil severance tax. So they're losing money. The cities are losing money. In addition, the state gets almost 90 cents a barrel right off the top. So all those things, kind of trickles down.
Thank you. Would there be any benefit from shutting down the 2 leases as compared to the cost of the shutdown?
We're not asking to operate the leases. Have them shut down already. They've been shut down since this happened.
Thank you.
Yeah.
And because it's in the health and safety code, I'll ask you that question again. Have you considered shutting down or curtailing operations instead of needing a variance? And
I don't know. you're asking here.
Oh, that's the next one.
Yeah, yeah, okay, yes. We've already shut in production at the leases.
Thank you. Are you reducing emissions to the maximum extent possible?
Yes, with the use of the vapor recovery compressors, will be controlled.
How will you monitor emissions during the variance period? Or when you have the compressor vapor collection and recirculation system in place?
The tanks have a monitor on them, so it's actually an electric switch that controls the solenoid valves, and we can monitor that to be certain that the pressure on those gauges that control the solenoid valves is within our limits below what the tanks would be emitting. So the tanks are equipped with equipment, the gauge hatch, and a pressure relief valve for emergency if there is a sudden burst of pressure, which rarely occurs. So you can monitor. We'll look at these daily, these gauges that are on the tanks already and part of the system.
Okay. And how are you going to get back to full compliance for all the different leases, the 3 leases?
We're exploring, as you mentioned, the use of permitted flares.
Have you found any permitted flares?
I have not found any permitted rental flares. I know we looked into that substantially with the companies and others that do rent larger equipment.
You have installed a district-permitted rental thermal oxidizer on the Whitney Barnes lease, which I believe has 6 wells. Could you do the same for the Pauley and Barnes Bush leases, which I think respectively have 3 and 2 wells?
Yes, those sites produce much less gas and oil. The units I've found are larger than what, and expensive, but they're larger in capacity than what those wells produce, which means that you have to burn propane. So the propane is, you'd be burning more propane than you would our gas probably. So it doesn't make sense to add to the pollution from these things burning. That's my feeling.
Thank you. So tell us a little more about what you've been doing, and I guess that's in Exhibit 9 too.
Yes, Exhibit 9 is a timeline of what we kind of have been going through here. Kind of tough, you can see, with the holidays in the middle of it. But the holidays, a few other things.
Have you contacted any vendors?
I have. I've been in contact with 5 different vendors. In addition, contact with operators in the field, other people that are kind of in the same predicament as we are. I think I have at least one proposal that we like for equipment now.
How many proposals do you have?
I have 3 proposals now, expecting 2 proposals by the end of the week.
Did you meet with any of these vendors?
Yes, I met with several. And you know, there's kind of two different types of equipment. One's big and requires outside fuel, the other doesn't. So that's much simpler. That's kind of the direction we're leaning.
Thank you. How long do you think this will take?
Well,
When do you think you'll be able to identify the best bid proposal?
I'm hoping to have all the bids this week, work on it next week, and decide something by the end of next week to really pin down what equipment we want to use.
Okay. Thank you. Yeah. Let's see. Then you'd be looking at applying for permits to the district to install, construct. Do you have a sense of how long that might take?
I've been told as much as 4 to 5 months.
Okay, thank you. And once the permits are issued, how long will it take to get the system from the vendor, for them to build it and get it to you?
Well, we're expecting up to 3 months.
Thank you. And then installation?
That should take, once the equipment is on site, it should take days, less than a month, I would hope, certainly.
Okay, thank you. So you're looking for a regular variance for how long, maybe?
10 months total, I think, is what we're expecting, possibly.
Okay.
Hopefully much shorter.
Hopefully shorter. That's good. Okay, that concludes Mr. Williams' direct testimony.
Thank you. So the date you're looking for is around November 8th? Is that 10 months?
Yes.
Okay, thank you. Ms. Reichart, questions for Mr. Williams?
Thank you. I believe that you had covered this in the previous hearing, but if you could refresh our memory, how much would it cost to clean the tanks, that procedure?
Well, that's another good question. It's depending on what's in the tanks, probably in the course of 2 days per tank. So that's probably in the range of $5,000 for the labor per day. Well, that might be high, but in that range. Okay. And then you have trucking and disposal costs. Antera was where we have taken product before. It's the most local. They're shut down. The Division of Oil and Gas, they're working with them on disposal permits. I haven't found where the next closest spot is to take it, so.
Okay,
So
thank you.
that's, the disposal costs are certainly more than what the labor costs would be.
Yeah. Have you had any detectable leaks since the last hearing?
Detectable leaks,
Anything
no.
that you detected?
No, there's no real odor, there's nothing like that, yeah, so.
And just, I want to confirm that I understand, in terms of your long-term, these plans that you're looking for, are you looking for thermal oxidizer units that you will install on each of the other wells that are
Yes.
smaller?
Yes, that is correct, yeah. We're designing to what volumes we have. They are older volumes, so we're gonna take some tweaking for sure, but we're looking into that or a permitted flare for the sites.
Okay. And so would those be, you said they're older designs, would those be fabricated from scratch, or would those be, you'd be adapting existing equipment?
Well, our data is old. The equipment would be brand new.
Okay.
Yes,
And can you pay extra to expedite that fabrication?
Yes, possibly, we'll certainly gonna try everything we can to get it as quickly as we can. There is a company in the local company, but the provider is in Tennessee. Okay. And they have kind of the cases built, and then they have to build it up with the burners and that sort of thing. Okay. So that is hopefully a good option. They're gonna provide a bid. That's one bid that I haven't obtained yet.
Okay, thank you. No further questions.
Thank you.
Thank you. I had a few questions. First I wanted to just begin, I had a question on your Exhibit 8, which is the rules for each of the different facilities. The only question I had was on the second page, the Whitney Barnes, that you continue to request variance relief from the description. The thermal oxidizer that you now have at the facility, is that your permanent solution?
No, it's I guess, what do you call it? A transient permit. So it's permitted through the district for a 1-year term.
Okay.
At any one site.
So the discussions you're having with vendors, that's also for the Whitney Barnes?
That is correct, yes.
Okay. So the 10 months will also include a permanent solution for that?
That is correct.
Okay, and once that's done, you will also request a permit modification for that equipment description as well.
Yes, as soon as we figure out the best equipment, we'll be in for permits. Certainly,
Okay.
certainly.
Okay, now I had just a few questions on the proposed variance conditions. If you can pull that up at the Exhibit A. My first question is, I just want to be clear that we're all on the same page. So with the first condition, it's ceasing and desisting all crude oil, gas, water extraction, et cetera, until such time as there is a fully operational vapor recovery system. You're talking about you are in agreement, that means the long-term vapor recovery system, not the compressor recirculation vapor collection system in condition 3, correct?
That is correct.
Okay. Also, I prefer for conditions 3 and 4 here that you have within 15 days and within 30 days. Since it's from the granting of the variance and it's not a variable date, could we put actual dates in there? Would it make sense to put January 23rd in condition 3 and February 7th? In condition 4, so that's, I think it's just 30 days, and it wouldn't be within, it would be by
By the 29th?
those dates. It's the 23rd right? We have 15 days, unless
Oh, business days.
business days, okay.
We think it'll be sooner, but I had asked for that.
Yes.
See, this is the reason why I like a date.
Yeah, right. As a clarification, I think
Really
that's,
is very clear that way.
yes, I think that's a good idea.
Okay. So we'll get those dates in there. I just wanted to make sure that that was agreeable. The next question I had was with regard to condition 2, conducting leak and odor surveillance. How will that be done?
Well, as we described, the gauges for the solenoid valves that open and close to relieve the pressure off the tanks, we can be looking at those gauges daily, or the guys are out there normally twice a day, and they can write down what those gauges are reading, and we'll know that it is below what the design on the tank hatch and pressure release valves are.
Okay, so I had had another question, because I know you did testify that you would be monitoring the pressure. So should it be leak surveillance, or should it be pressure surveillance, or should it be both? I just want to make sure that we're including that in there and understanding what that means.
Yes, the pressure of the tank is what we'd be looking at,
Tank pressure.
and the pressure that's in the tank itself.
So it's not leak or it is leak. So it's petitioner shall conduct pressure surveillance or pressure monitoring and odor surveillance? I just want to make sure we understand.
Yeah, we'd be monitoring the tank pressure, and the design of the tank is such that it shouldn't leak when the pressure is lower than that number.
So monitoring tank pressure, okay. Is there a way also to get any readings to find out if there are any emissions that are coming out of the tanks?
Well, we can inspect for that.
Okay, and is there how would you do that? Do you have any portable devices, or?
I would defer possibly to Carl.
We could wait if there's another witness who would be better suited to discuss that?
Yes.
Okay. I'll hold that, okay. The other question I had, so you've laid out what you believe might be a 10-month process, but what I'd like to see in the proposed conditions is along the lines of that, within 30 days, within 15 days. I'd like to see conditions that by such and such a date, you will pick a manufacturer or a system for each. Within 15 or 30 or however many days makes sense, you will submit applications to the district. Within such and such a number of days of receiving the permit, you will begin installation, so that we bring you along to that 10 months. If we could, maybe on a break, come up with those conditions.
And keying it to receipt of the permit would be helpful in terms of,
That would be for the
Any uncertainty.
installation, and I think if you wanted to pick a reasonable time frame to make a decision on the various vendors and systems, and then key off of that for when the application needs to be submitted to the district. I understand that what the district does with that, you can't control, unless also if you wanted to put in expedited processing, I don't know.
Oh, yes, we certainly will expedite.
So so if we can, maybe on a break, do that kind of, maybe you can have a discussion and we can come up with those. And those were my questions. Anyone else have? Ms. Verdugo Peralta has questions.
Thank you, Madam Chair. Mine are more of a clarification. When you were talking about the Polly and Barnes Bush facilities, you talked about the heat. I'm assuming that that was ambient temperature, not an artificial source of heat?
That's correct.
Okay. And then the other question, I also agree with the chair, we need to have some type of a gate chart or something similar to your timeline so that we know by such and such a date, you're going to contact so-and-so, just as she mentioned. I think that needs to be crystal clear for us as well as the district. And pretty much, oh, I had another question within that chart, or a gate chart possibly, or a timeline, because I was trying to write as quick as I could, and I did not catch that first subject, which was the 4 to 5 months on your timeline.
Would you like Mr. Williams to go over that timeline again?
Please.
Okay, where were we here?
it's the end of your testimony. I have page 15, but it's, how are you going to get back in compliance?
Okay. That's, I'm sorry. Okay. Page 15. Okay, what our estimates are, hopefully by the end of January, certainly we're working towards next week, end of next week, to pick a system. And we will be contracting with somebody to help with our permitting process. I think that's permitting is expected to take between 4 and 5 months, I understand. I don't know if that's an expedited time period or not. I guess once we submit, we'll maybe know a little better what that is. And then the vendor, what I've been finding, they require between 2 and 3 months to construct the equipment, depending on where it comes from. If it's local or coming from Tennessee, there'll probably be some shipping time. And in addition, installation, possibly a month, by the time we get everything ready to be, including source testing and whatever it may take, so.
For installation.
Yes, for installation, yes.
That's what I needed, thank you.
Other questions, board members? Senator?
On October 2019, that was the first time in your knowledge that Signal Hill experienced a problem. Yes or no?
Yes.
And how long have they been operating this process since you received a permit?
Our permit was long before that time. Our permits go back over 30 years.
30 years. So for 30 years, you've been aware that you had to comply with the conditions specified in the permit, is that correct?
Yes, sir, as far as going to their gas line.
Yeah, for the permit associated with the problem that we're discussing today.
Yes.
And until October, there's never been a problem. Is that what you're saying?
Not a serious problem. They've
Had
had,
never been a problem, serious or otherwise.
they've had some upsets over the course of time.
And what?
They've had some upsets over the course of time.
What's the definition of upset?
Well, we were going to Lamita operating line, and Lamita had a fire in their plant, and that's the last time I was in here for a variance.
But you
that's
never,
been-
you didn't receive a notice of violation for that.
No, I don't believe we did.
How many NOVs have you received?
Do you want to give a time frame over the course of their history, or you mean
No,
for
per-
this,
per
for this situation?
Per this type of condition. I don't need a time frame. I want to know the total number that you can recall.
The total number that I can recall, we had certainly nothing in probably the last 5 years. We had probably 8 or 10 years ago, we had some compliance with tank sizes. We had reduced some of the tank sizes, and a previous inspector had written on our permit that it was okay. The inspectors came out, and they found that it wasn't in the district's computer system, which was not applicable. I mean, there wasn't a computer system when that happened, as well as some scrubbers and things that I don't know that we needed to have changed, but we put them on the permits anyway.
I'm concerned with the vapor leaks.
Vapor leaks. We test for vapors quarterly. And so we have a company that comes out, and they go around with a sniffer, and they check the leases. So we're very particular about what goes on.
Have they discovered any excess leaks in the previous years?
There's minor leaks.
Do you document when you have a leak?
We do.
Keep a record of it?
Yes.
Provide it to the district when they investigate?
Yes.
It's right near the facility?
Yes.
Okay, you were saying that Signal Hill is responsible for the leaks.
They're responsible, or we're responsible for taking and providing a vacuum to our leases.
Well, did Signal Hill apply for a variance to do this? If they're in violation, they contributed to the violation. Let me,
The Signal Hill is not in violation currently. Signal Hill simply is no longer receiving the gases for vapor recovery, and that's why we're here today.
well, they are receiving, they intend to receive it. That's why they're here. For variance, they allow them to do it.
No, they are no longer receiving their gases, so the facilities do not have, these oil and gas producing facilities have nowhere to send their vapors. That's why they're asking for the variance today.
Then if they have nowhere to send it, where do you plan to send it?
We're going to put, with the vapor pumps, we're going to put the gas back down the casing until such a time that we can get equipment that is permitted through the district to destroy the vapors.
So you will not be doing any more work with Signal Hill?
No, that we're physically disconnected from their lines,
Total.
totally. After, as long as I can remember.
How far back can you remember on that?
Well, when I started, probably 35 years ago, everything was connected to their line, or Lamita operators before them.
When you begin to disconnect from them?
Pardon me?
When did you disconnect from Signal Hill?
That was on the October 17th, 15th date.
When?
October 17th of last year.
Well, last year, okay, fine. You also talked about you expecting bids to address the vapor emission. You get them in?
Yes, sir. I have 3 bids now, and I'm working with 2 other companies to provide bids.
They give you a timeline?
Yes, everything kind of got at a standstill over the holidays. And first of the year, I picked it up with every one of them and said, hey, I need this, and we're going to a hearing today.
And the bid, they have a timeline when they could start the job, when they finish. You have that.
Yes, for some of the companies I do.
And on the exhibit, I think it's 9. Pardon? And the last item, 31. You have a temporary fix in place, is that correct?
For the Whitney Barnes,
Yeah.
yes, we have a rented unit.
Did the district approve the operation of this?
Yes,
Control leaks?
it's permitted through the district.
That's permitted. All right. Okay, thank you.
Thank you.
And just to be clear, because the senator was referring to lines 30 and 31, those have to do with the other two leases, correct? Pauley and Bush Barnes? And that is the temporary device to keep the pressure to minimize any releases while awaiting the final vapor recovery system, correct?
I'm sorry, I was assuming you were referring to the permitted thermal oxidizer. No, those are the vapor pumps. They're three horsepower, and my understanding is they're not required to have a permit.
They're electric.
Yes, they're electric.
And those are a temporary fix in terms of minimizing vapor leaks?
Yes, they'll control the vapors on the tanks. We won't be operating the wells, so there won't be additional input into the tanks. They may become part of our permanent solution because we're going to have some sort of control on the tanks. We're going to have some means to provide a vacuum to pull the vapors off of the tanks. So I imagine that they will become part of our permanent solution.
Thank you. Is that clear, Senator?
For now, yes.
Okay.
I may have further questions later.
Okay. Mr. Balagopalan has questions.
Yes. Mr. William, I think at the last hearing, the reason Signal had stopped taking your gas is because of the high BTU content.
That's correct.
And you were looking at blending it with natural gas and so forth, and that has not been successful?
No, a couple problems is the volume of gas it takes and also the pressure. To put the pressure off the city line and then go back into their line, it wasn't compatible really. It's to make it blend, it wasn't compatible. I looked into it some and other operators in the area, and no one was able to make that work.
So is Signal Hill changed? I mean, their limitation right now is what's anything higher than 1350 BTU is what they won't accept. Is that?
That's correct. They originally started at 1,500 BTUs, and that was with the Moore and Douglas. Not to get off topic, but those wells were operating. That's why they're not on this variance. So they were operating, and then days later, about the time we applied for this variance, they shut those wells because they changed the BTU rating from 15 to 1350.
And your facilities historically have much higher than that?
Yes, well over, for the most part, 1,600 to as high as 1,800.
But because of the new restriction, because of the operation, you're not able to supply. Is that's
correct. They're a gas plant. They have a gas plant that strips BTUs, strips propane, different high ends off the gas, and then they're able to put that into the city line, either the city of Long Beach or SoCal Gas. My understanding is they go into both of those. They've also tightened the restrictions recently on the gas lines, so if their gas is out of compliance, they shut them down for 2 days. So that's part of the problem, and addition to the generator unit that they have. They have a solar turbine generator. That, they had a catastrophic problem with that, and they were able to get it warrantied, is my understanding. And consequently, due to that warranty work, they put all sorts of monitoring and shutdowns and different things on that equipment to control the BTUs going into it, or at least to check, make sure they're not having high BTUs. They suspect that that was part of the problem that blew up the generator, so.
So going back at the conditions, bearing condition, one of the, condition number 6, does say, notify Mr. Taylor, any change in the status of the Signal Hill Petroleum ability to collect vapors. Do you foresee that happening, or is that done?
No, I don't see that happening. We're physically, they bull plugged, put plugs in the line, so we're not, I don't see that ever gonna be an option for us, unfortunately.
Now, when when they were collecting your gas, there was a beneficial use of it, basically, because they use it in their turbine and generated electricity and so forth. And so are you also, in your options that from what I'm seeing or what you've indicated, you're just looking at flaring it or burning it off? You're not looking at any beneficial use of generating heat or power or anything like that?
That is a possibility. It takes quite a time. At one point in time, we did have a generator running on the large lease of Whitney Barnes, and it takes quite a bit of time to get that in place with the Edison, and it's tougher now than it used to be at that point in time. It's still possible. One of the companies we're working with, they look for uses of the heat, and as well as generation.
And what's your consideration in selecting one vendor versus the other, besides, I'm assuming, cost and,
Yes, cost and is really always a driving factor. We'd love to be able to profit and use it, and hopefully that may be an option. Not talking about that today. We're talking about the Barnes Bush and the poly leases. They don't have enough gas at one site really to run a microturbine or something like that. It's be right on the edge maybe, and certainly it doesn't have enough gas to warrant trying to get into the city line.
and you're not looking at connecting all your leases to one, like you had before when you went to Signal Hill?
Yeah, Signal Hill owns that line that runs all over Long Beach. We're probably in the range from 4 miles to 2 miles maybe apart. So that's probably not an option.
To tap into it and,
Yeah, and to Signal, well, then we're just back into Signal Hill vacuum line, yeah. So it's difficult to run lines, particularly for gas.
I think Ms. Bruce asked a condition on your leak monitoring, and you did mention the one option, I mean, you're going to look at pressure for the release from the tanks. That's a good indicator to indicate if there's any release there. And you do quarterly monitoring, and that's, when was the last time the monitoring was done, and what was the results of that?
I don't have it in front of me, unfortunately, but we do it towards the end of the quarter. We're probably due to have it done again. So that maybe that would qualify as our inspection.
As far as the leak monitoring?
Yes,
And is it something you can do on a little bit more frequent basis? I know the rule requires a quarterly monitoring, but if the board were required to do it in a more monthly basis, is that a hardship or?
No, I mean, it's an expense, certainly.
Okay.
I think the next witness was going to perhaps illuminate, but we'll
Well, I
wait for
just wanted
that.
to know from Mr. Williams if there's a, because that's one way of monitoring any leaks and so, but you don't have capability, you don't have OVAs or on site that your operators have to look for
No, we
sniffing or
don't.
anything like that?
We don't. We contract everything, yeah, like that, yeah.
How about odors? How do you, I mean, if your operators, you get sensitized to the smell if you're walking around there, so how are you going to be able to detect, because one of the condition is odor surveillance, so is that contracted out, or is you going to depend on personnel at the site to do that?
We contract all our, everything we do, other than our books. My sister does the books, I kind of do the engineering and,
So when it says do the odor surveillance, so who's going to do that?
our operator, our contract operator.
Contract operator?
Yes, uh-huh.
And they are always on the site?
They go from site to
Site
site,
to
different sites, yes,
Okay.
for our company and other companies.
Okay, thank you very much.
Thank you.
But they're at each site at least once per day.
That's correct.
Okay.
So that would maintain the leak and odor surveillance part and add the tank pressure monitoring to condition 2.
I think we need to have the leak and, and also the tank monitoring.
Agree. Agree. Anyone else have any questions before we take a break? Senator has more questions.
According to Exhibit 9, you spoke to a lot of companies on vapor recovery system. How can it assist you in controlling this emission at your site, correct?
That's correct.
And only 2 responded,
As of this date, 3.
3, and
That was yesterday.
Yeah, yesterday I got the third
like Clean
proposal.
Energy, they got a good reputation,
I believe so, yes.
and they can get it done. What about Mako?
We're still waiting. I went out and visited them. We're waiting on their proposal.
To your knowledge, if you can recall, how many companies did you talk to regarding this vapor recovery system?
Probably 8.
And they haven't shown any interest?
Well, the others didn't believe they could do the job for us.
I see,
They
okay.
provided larger equipment for the most part.
Okay, thank you.
Any other questions? Okay, so we'll take a break, and I wanted to list off some of the things that I think we would like to see, if it can be discussed at least over the break. More, oh, yes, no, I don't mind. Go ahead, Senator.
You've seen the proposed various conditions, correct?
I have?
Can you comply?
Yes. I'm sure we can.
With the timeline, like take condition number 4. Detailing the action plan to address these conditions. You can do that.
Yes.
And condition number 3, within 15 days of granting the variance.
Yes. We're working on that today.
Okay, and number 6, that's easy, okay, fine. But number 1 is the more key one. If to cease operation until all these conditions are met. You can do that?
We're shut down now.
You shut down?
Yes.
And you will not operate until you comply with this condition number 1?
That's correct.
Oh, very good, thank you.
Thank you for that. And we have, so what I have in my notes is to provide a date certain in conditions 3 and 4. Also to have the following within a certain number of days as conditions. Number 1 is when it is that you intend, and this could be a date certain too, intend to pick a vendor and a system for each of the leases. 2 is within so many days to submit an application for permits with expedited review, since you indicated that's something you would want to do. A condition with a timing as to when to place the order for the equipment, and one more within so many days of receiving the equipment to begin installation. And then finally, we wanted to also do something to separate out or to be much clearer with regard to leak detection and how that will be done. And so why don't we take, so that can be discussed, and we could take a break. Why don't we take about a 20-minute break, and we'll come back at 10:35. Okay, we are off the record.
I'm sorry, I had a question.
Sorry, back on the record.
Thank you. With regard to ordering the equipment, that would be within a certain number of days from receipt of the permit to construct?
Whatever makes sense and is the correct,
Thank you.
yes, thank you. Okay, now we are off the record. Okay, we are back on the record, and we've received both a clean and a red line version of a amended proposed regular variance conditions. And let's mark the red line version as Exhibit B, as in boy, and, sorry, the marked up, cross out,
Yeah,
black
it's not in
line.
red, sorry.
And then the clean version of the proposed amended variance conditions will be C as in Charlie. And then, right before we came back on, Ms. Reichart was walking us through this real quickly.
So, condition 2 includes the tank pressure monitoring. Condition 3 adds the date certain. Condition 4 is requiring the selection of the system and the vendor by January 31st. Condition 5 has a date certain. Condition 6 requires submitting the permit applications and requesting and paying for expedited processing by February 15th. Condition 7 requires that they place the order for all sites and request and pay for expedited fabrication and shipping if available, no later than 7 days after the issuance of the permits by the district. Condition 9 requires that they commence installation within 7 days of receipt. Condition 10 requires that they complete testing and commence operation of the systems within 60 days of receipt. And that's it.
Thank you very much. And this has been agreed to by both sides?
Yes.
Okay. Thank you very much. It's very helpful. And with that, Mr. Tether, did you wish to present your other witness today?
Yes. I think primarily on how, well, I'll go ahead. The other witness is Carl Laney from Montrose Environmental. Mr. Laney, could you please?
Sorry, yes, Senator?
If he's going to speak, sir, regarding the proposed variance, fine, other than I'm satisfied. You look at the proposed variance, you're going to speak to those changes, that's fine.
Yeah, I don't know what he's going to give testimony on, so let's allow, okay. You may continue.
Actually, I'm not sure we need to introduce another witness if the board feels that we're,
Well, I know that Mr. Balagopalan was hoping to have a witness perhaps for the district, but does anyone, before we do that, does anyone need any other information that you need from a witness for petitioner? Yes, Ms. Verdugo Peralta.
On number 12, are we going to be given a date?
That's a date we supply.
I'm sorry?
That's a date we would supply.
Okay.
Madam Chair, I had a question for Mr. Laney regarding the,
I can introduce him then.
okay.
Okay, then
Thank you.
let's, yes, thank you.
Yes. And yeah. Oh, Mr. Laney, could you please spell your name for the record?
Karllany.
And Mr. Laney, have you taken the oath?
Yes.
And could you give us the background that you have in this case? Your connection?
Our company, Montrose Environmental Group, performs Rule 1173 monitoring for the S&C oil sites. Mr. Williams contacted us at the onset of the situation we're in right now to talk about options for coming into compliance and dealing with the district and the hearing board, given the events that occurred at Signal Hill.
Just a question for clarify for me is Rule 1173 monitoring also known as LDAR, leak detection and repair monitoring?
That's correct.
Okay, thank you. I was going to ask you just how you calculated the excess emissions, but you want to touch briefly on that, and then I think that's probably the end of the direct testimony, and he'd be available for questions.
Okay. In this particular case, because production has ceased, emissions from these two sites would be limited to tank vapors due to temperature changes, ambient temperature changes. We used EPA tanks 4.0 to calculate those emissions using standard acceptable default values and ambient temperatures for the Long Beach Signal Hill area. Same process that would be used for emission inventories under Regulation 3 and under permitting at South Coast.
Thank you. Well, that ends our direct testimony from Mr. Laney. Thank you.
Ms. Reichart, any questions?
No questions.
Sorry, can you tell us again, because I might have missed it, what are the expected excess emissions?
Based upon the tank's model for the poly, for the poly lease, we were seeing 3.3 pounds per day of VOCs and less than 0.1 pound per day benzene. That's based upon a daily annual average. So one of the components that affects those emissions are average ambient temperatures. In the winter time, the actual emissions would probably be estimated about maybe 80 to 85% of those numbers. In the summertime, when it gets hot, maybe 15 to 20% above. So it's an annual average.
Okay, and that's for poly. Did you have for the other two as well?
For the other lease, I believe we were looking at 6 pounds per day of VOC, and again, less than 0.1 pound per day of benzene.
Okay, so that was for the Bush barns.
That's correct.
And you don't expect, because you have the temporary thermal oxidizer, you expect none from Whitney Barnes?
Whitney Barnes would not have excess emissions, no.
Okay.
And I'd like to point out that these are excess emissions that were calculated assuming that the recovery system that we have been talking about today, even on the smaller lease on the Barnes Bush, the smaller leases where we have the compressor with the recovery system, it's assuming that that system is not in place.
Okay, that was going to be my next question. So that is without that being in place, that system being in place, but so you do anticipate it will be, hopefully none, but it will be less than. So this is these are conservative estimates.
Absolutely,
Okay.
absolutely.
Thank you. Any other questions on that testimony or anything else related? Mr. Balagopalan?
Mr. Laney, do you know when the last time the monitoring was done as per for Rule 1173 at the facility?
I do not know the date. I do know that we do it quarterly. My presumption is that this new equipment, the pipes, or the valves, the fittings, the compressor, would be rolled into that Rule 1173 monitoring program as we go forward.
Do you know if they were showing any exceedance based on any previous testing?
I'm not aware. Anything that would have been detected would have been within the levels of Rule 1173 and dealt with accordingly with 1173. So compliance exists.
So, and I'll ask the same question of the district staff. Do you see a need for doing more frequent monitoring during the period of the variance?
I don't, actually. I don't see anything inherently different in the nature of the piping, the fittings, and the components of this add-on recirculation system that would make it more prone to leaking or less prone to leaking than the rest of the facility. I don't see it as adding to or detecting or taking away from the propensity to have leaks. In my observation of all this, it seems to me that the real issue of knowing whether or not the system is doing what it should be doing to prevent the escape of vapors from the relief valves would be to truly monitor on a regular basis the pressure levels at the tank pressure relief valves and the pressure levels at the new compressor system. I do believe it makes sense once the new fittings are in place and the compressor is in place, we should at a minimum do a startup 1173 type leak detection assessment to make sure that all the valves are connected correctly and all of the components are working. I don't know that in my mind I see a reason to step beyond Rule 1173 from that point forward.
To the point you just alluded to, should we then make that a condition, though, that after the compressor system is in place to do 1173 type monitoring?
I would be more favorable of that and say that, for example, in condition number 2, I think it makes sense the pressure is monitored daily. I think that odor is surveilled daily. I would believe that instead of daily leak detection,
Oh, yeah,
we would have startup and a roll-in of 1173.
Wait, we should stop there because it now reads daily leak.
Yes, it does.
And so are you wishing to change that proposal?
I would be open to that in light of Mr. Laney's testimony, assuming it meets the board's concerns. And it sounds to me that it does.
I would like to hear from Ms. Reichart since that,
Well, he's not, no, tell me.
okay.
And then I can.
Yes. And if it's going to require testimony, we'll get that later.
Okay. Well, he could testify to it, but basically because it's using the word surveillance as opposed to detection, that he felt that this would be sufficient, but I can have him testify.
Why don't we'll hold that.
Yeah.
Uh,
Did you?
It's the presumption that's
Madam Chair, I just wanted to clarify that we're asking the question regarding the possible additional emissions from startup. Is that what we're looking at here?
We're trying to understand what is included in condition number 2
Right.
and how we want to word that.
Just for clarification, it's not startup, it's after they install the compressor unit to balance the system and inject it into the well. That
But
after,
that's part of startup system,
it-
isn't it?
it's
The
not,
protocol?
it's not, well, it's not I don't know what you mean. It's startup, it's a measure they're going to take place, so they're not going to start operating, they're just going to.
Well, if you have further questions, let's ask them, but, and have the witness answer them. But let's start first with what is here and what is intended and what is going to be agreed upon by the parties.
It's my understanding at this point, and that was my initial understanding of the original condition, and I'd be happy to hear clarification of that.
Yeah, let's
But
wait, let's-
that leak
Let's
surveillance,
wait 1 second until we have counsel listening. Okay. No, that's okay, because we want to make sure we're on the same page. So we're talking about condition number 2 and the understanding of petitioner.
yes, it was our understanding that leak and odor surveillance could be done daily and would be essentially as a staff person, an operator, walking around the site, listening and smelling for leaks or odors. It was not leak detection in the sense of Rule 1173. We would certainly not have expected an LDAR third-party inspection on a daily basis.
And that was our understanding as well.
Okay, now, did you have further questions, and then Ms.
Yeah, I think
Federico-Plata might have?
what Mr. Laney had suggested, which I think is a good suggestion, is that after they install the compressor, the unit, they will do a 1173 type leak detection, and then go forward on a quarter, whenever the next schedule is. And it's not a daily thing, just a one-time after everything is set up and, because you said, like you said, you have to adjust the valves and so forth to do that. So then just to make sure everything is okay. So if you can propose some condition regarding that for number 2, then,
Or maybe we just add it as
add it,
another condition, so it doesn't muddy this condition too much?
Thank you. Within 7 days, of installation and operation.
And I would think this would be condition number 4, because 3 is the actual installation.
Petitioner shall have a Rule 1173 inspection done for the new system. Well, that's part of it.
We'll do the quarterly, we retract it to the quarterly.
Should it be within 7 days? Yeah, and quarterly thereafter. Did you hear that, Mary? Is that accepted?
Yes,
So
that's
that would
agreeable.
read.
Okay, so, yeah, let's read that.
That would read, within 7 days of installation and operation of the system. Oh, of course. I'm very sensitive to that.
Let's, just so we have consistency, let's start with petitioner shall within
Okay.
7 days.
This is number 4. Petitioner shall, within 7 days of installation and operation of the system required by condition 3, and I'm even slower, I print. Or as my wife would say, let me write it, dear, so people can read it. Have a Rule 1173 inspection done for that system, comma, and quarterly thereafter. Period.
Thank you. Any other questions for Mr. Laney, Ms. Verdugo Peralta?
I'm not sure whether this is for Mr. Laney or not. I would be remiss if I didn't ask, and maybe we did discuss it in the previous hearing, but is there any necessity to notify the surrounding public? I don't know what the proximity is to any neighborhood or schools where your facility is, but as a general question, has that been looked at by the district?
Let's, if that is directed at the district, I know that Mr. Balagopalan also has a question for the district, and we can have Ms. Reichart introduce her witness. So, okay, so we'll hold that. Any other questions for Mr. Laney? Okay, thank you very much.
Thank you.
Okay, Ms. Reichart, can you introduce your witness?
Yes, thank you. Could you please state and spell your name for the record?
Yes, my name is Jason Taylor, Jason Taylor.
And did you take the oath this morning?
I actually did not because I wasn't planning on testifying, but I'd be happy to take it now. I do.
Thank you. And what is your position here at the district?
I'm a senior air quality engineer. I've been over the oil and gas permit processing for approximately the last 5.5 years.
And are you familiar with the facilities at issue in this variance hearing?
I'm not intimately familiar with them. We have a large volume of facilities, but I have a good understanding of what's going on at the 3 sites.
Great, thank you. And I have no questions, so I'll turn it over, well, to the board or.
Let's begin, since Ms. Verdugo Peralta asked her question first. I don't know if you want to repeat your question, or if you heard that question.
I did hear the question, with regard to the close proximity of schools. I would actually have to go back and check to find out. But anytime there's an application that's submitted to modify or to install a new piece of equipment, there's a thorough analysis that's done pursuant to Rule 212 to identify if there's a close school located within 1,000 feet. In the event that that's the case, there would certainly be a public notice distributed both to the students of the parents of the student body, and then to any businesses or addresses located within a 1,000-foot radius of the facility. There's also some additional public notice requirements under Rule 212 that could potentially trigger notification, but that's something that's certainly investigated on a case-by-case basis anytime we receive a permit application.
So that will be conducted as of a matter of course, when the permit applications are put in.
That's correct.
Okay, thank you.
Thank you.
Mr. Balagopalan.
Actually, my question would be more relevant if have you been to the site?
These 3 specific sites I've not.
Yeah, so my questions are more, trying to, if you know what the neighborhood is. And more direct, if they were to, right now, all the gas is piped. There's no combustion going on, except for the site now, the Wills, that, where you have the RTO. But I'm just wondering if a flare is installed, now suddenly you're going to see flaring. It might be visible, I'm not, depending on the type of flare. Would that be a concern for the community, or, because that's something that didn't occur before?
It's certainly a possibility. I mean, we've seen some concerns with regard to oil and gas fields, depending on the location. There's, if there's a notification required and people become aware of the project, that's certain cause. I don't think anybody, particularly wants anything within close proximity to their schools or their houses. But I can't honestly, guess at this point whether or not there would be public response or public adversity to it. I mean, it would just be a case-by-case basis. If there's a trigger by Rule 212, we certainly would do notification. But even if Rule 212 isn't triggered, the general community will, they may see some sort of a visible nuisance that they don't like, or have problems with ambient sound. That's something we wouldn't be able to really foretell before we see what's proposed by the applicant, and we do a rule evaluation, pursuant to Reg 4.
Quite frankly, I was hoping to hear from an inspector who had been to the site to if he had an idea what the neighborhood is, but you
Yeah,
have not
correct.
been.
Yeah, unfortunately, the compliance staff was here, the inspector was
Yes.
present in the morning, and it looks like he didn't come back after recess. He would be able to provide you with some additional testimony, I think, that would answer your questions.
Okay, thank you.
Would you like to ask the facility what the surrounding area is like?
I believe we are, well, yes.
Okay.
Yeah, I think that might be the best.
So, Mr. Williams, if you could answer that.
Yes, the Barnes Bush is kind of out in a field by itself. It's in Long Beach and borders Signal Hill. We're in a proximity to the Long Beach Hospital there, but it's further than the 1,000 feet, I believe. The poly lease are 3 wells, and it's industrial with bordered on one across the street from some residents.
And Whitney Barnes, I know you have
Oh, the Whitney, yes, I'm sorry. The Whitney Barnes is, it's in an industrial area.
and you have RTO, I mean, a temporary,
Yes, and it's been running for nearly 2 months, and we haven't had a noise or an odor or any kind of complaint on it.
and where is that located? I mean,
That's the northeast corner of Willow and Orange in Signal Hill.
what kind of neighborhood?
Industrial,
Industrial.
yes.
So do you potentially see any issues from the neighborhood if you have a flaring, or if you choose to go with the flare?
My understanding is anything is not going to have a noticeable flame. One equipment that we're looking at right now is 8 feet tall. So I think we'll probably put up a fence around it, specifically around the unit itself. The site is fenced as well as around the unit. And if it takes some soundproofing, we'll put soundproofing up, that sort of thing as well.
Okay, thank you.
Senator.
You responded to a question that at Signal Hill, you planted adjacent to Signal Hill.
The sites, one site, the Barnes Bush, is, one well is in Long Beach, and the tank setting and the other well, the second well, is in Signal Hill.
So Signal Hill, there's no production anymore at Signal Hill. That's shut down. Is that correct?
Those two leases are shut in, yes.
Wait a minute. Is it operating there or not operating there?
They are not,
At Signal Hill.
they are not operating, those two leases.
Well, Signal Hill itself is operating, but the two leases you're talking about that were otherwise piping gas to Signal Hill, those two leases are shut in, is that correct?
That is correct.
Clarification, Signal Hill Processing, whatever the name of that facility is, or is it Signal Hill Refinery or Signal Hill?
Petroleum.
Signal Hill Petroleum.
Petroleum, yeah,
Signal
but
Hill
that's it.
Petroleum, they are their own entity. I believe they have wells that are shut in as well. I know they have a lot of wells that are producing, and they're putting the gas to the generator and the gas plant and to the city line, I assume, still. I don't have any control over what Signal Hill does, unfortunately.
It's not part of your operation then?
No, not at all.
Although you have one producing plant adjacent or near Signal Hill.
There's two things. There's the Signal Hill Petroleum Corporation, and there's the city of Signal Hill. We have three sites that we're talking about today. They are all in the city of Signal Hill.
Signal Hill Petroleum Operation. You're not doing business with them, is that correct, or you are?
We are not, no.
Okay.
Okay, board members, any other questions, since we've sort of opened it up for everyone who has testified? Any other questions before we close the record? Okay, before I close the record, I'm going to ask, I don't see anyone in the audience, but is there any member of the public who wishes to be heard today? And I see none. So we are going to close the hearing and proceed to closing arguments, or statements, I should say, beginning with Mr. Tether.
Thank you very much. You've heard the background with regard to S&C using the Lomita gas line and then the Signal Hill Petroleum gas line for about 40 years, and now is precluded from doing that. They filed a variance petition 2 days after realizing that the situation wouldn't improve, that they would be more, at that time they were fairly sure, and now they're certain, that they will never have access, at least not in this era, to Signal Hill's turbine and vapor recovery. There's still, at least right now, some potential for small amounts of vapor emissions from process tanks. They've been diligent, and Mr. Williams described his contacts with vendors and also looking for something that might be able to return the Pauley and Barnes Bush lease to compliance more quickly, such as what has been able to be done at Whitney Barnes. But at this point, they have not found anything that really would be compatible with those two smaller leases. And we have agreed to a timetable now in the conditions for them to move forward to identify a vendor and equipment that can return the lease to full compliance. And I'm familiar, I believe, with the vendor that Mr. Williams mentioned would consider microturbines or other options if those would fit, although perhaps they would not for a lease with 3 wells and 2 wells. Certainly I have taken them to task for this in this building, but the California Public Utilities Commission requires a minimum of 1 megawatt per day to take electricity. That's something that Signal Hill achieves. Their turbine is about 4 megawatts. And so we respectfully request a variance consistent with the conditions and the timetable therein. Also, given the fact that S&C is not producing oil at Pauley or Barnes Bush leases, and even before the vapor collection and recirculation system has very minimal emissions, and we hope no emissions after that system is in place and operating, we respectfully request a 75% reduction in the minimum daily excess emissions fee of $199.09, which would make that fee $49.77. We request that pursuant to District Rule 303G. Thank you, and thank you for this opportunity to appear.
And just so we'll take that up second, your request for a fee reduction. But just so we're clear, is that based on hardship or otherwise inequitable?
Based on, based on the fact, in terms of hardship, in the interest of reducing greater emissions, S&C is continuing to not produce oil from these leases, and also not from the other two leases we'll be talking about in about a month. For the Pauley and Barnes Bush leases, that's about $3,500 a day in revenue. So that's certainly a significant incentive for them to move as quickly as possible on the steps that are laid out in the agreed to conditions. Beyond that, it's if we calculated the excess emission fees according to the schedule, I suspect it would be in the range of $1 or $2 for the amount in question, and virtually nil if the opportunity should arise for us to independently demonstrate to you and communicate that there are literally no excess emissions. We will do so, although we're not quite able to do that today. But we do have substantial hope for the vapor collection and recirculation system and its potential to eliminate excess emissions. Thank you.
And just one other question. And it's your belief that that adjustment would not occur under the other provisions of 303 regarding adjusting fees because the minimum would apply based on the amounts?
Well, I think it's Rule 303G that gives the board the authority to adjust fees in accordance with the factors that you mentioned.
It's two separate. One would be, usually we have petitioners pay within 15 days what they expect to be the excess emission fees. And then there's a provision for adjustment between the petitioner and the district later on. But what you're talking about is 303G. And
Yes,
I just
that's
wanted.
correct. And thank you for mentioning the other, and we would certainly hope to be able to take advantage of that.
And that's why I'm wondering why, are you making an argument that that you would prefer to have that adjusted in advance?
Well, it's two separate steps is what I'm suggesting. I think if we were able to prove that there were no emissions, we'd ask for no excess emissions fee. All the time recognizing that
Okay, 303.
their lack of production is a significant incentive for them to move forward. Sometimes the excess emission fee can be an incentive for the petitioner to not sit around and wait for the variance to run out, but this is not that case.
Okay, we'll look into that. So you're looking at G and, okay. Just wanted to make sure we had your full argument before I closed.
Thank you.
Okay. Ms. Reichart, you're closing.
Subject to compliance with the proposed conditions as amended in Exhibit C, the district is not opposed to the granting of this variance. Thank you.
Okay, board members, anyone wish to begin discussion? Just start the discussion of our findings. Yes, Mr. Balagopalan.
Yeah, I believe we can make the 6 findings to grant the variance. The petitioner, it's in this situation because they used to pipe the gas that was produced to Signal Hill Petroleum, but due to unforeseeable circumstances, they are no longer able to do that because their BTU rating for the gas produced is much too high. So, so it's beyond their control. But going through the sixth finding, they are in violation of will be in violation of the rules that are stated in the petition and some of the permit condition, because it does require the permit it to be vented to a vapor recovery system, and currently they're not able to vent it to Signal Hill Petroleum, so they're in violation of the permit condition and some relevant sections of the rule cited. And the non-compliance with the district rule is beyond the reasonable control, because they didn't anticipate this happening. For 30, 40 years, they've been shipping that to Signal Hill Petroleum, and then due to what occurred at Signal Hill Petroleum with the failure of their turbine, and then the restriction on the quality of the gas that they will receive, that they're in this quandary. So they have to now look at alternatives to burn off or dispose of the gas. And while I encourage the facility to look at beneficial use, and I realize that I think Mr. Williams mentioned that in some of these facilities there's not enough gas to run a microturbine and so forth. It just seems, when you're burning and flaring, it's just a waste of resources. But nevertheless, they are looking at one of the facilities. They have already put in a control system, and they've been operating for 2 months, so that's been controlled. I think the other two facilities, the procedure that they are going to follow to implement to install the compressor will help to minimize the emissions during the time frame until they select a vendor to control the vapor and have a vapor recovery system in place. So I think that's a good step to minimize the emissions during that interim period until they select a vendor that can control those that can install a control system that will control the emissions from the tanks and other operations. So the closing or taking would be without a corresponding benefit in reducing emission. As it was indicated, both the two leases are not in operation; they're not producing. However, there will still be breathing losses from the storage tank. I think we also heard that to clean out the tank and to degas it will probably not only cost, but it will also actually create its own emissions. So since they're taking the steps to minimize emission with the shuttling the gas between the pipe into underground storage and then back into, as needed, into the tank, I think will minimize that. They have given consideration curtailing emissions. So it's shut down, they're not producing, and they are taking steps to minimize the losses from the storage tanks. So that will also reduce the excess emission to the maximum extent possible. Now, Mr. Feather mentioned there's a 75% reduction. A number is thrown. I don't think we can quantify or verify that. So I know we'll be discussing the fees later. So I have a little reluctance in accepting a number that is given without any kind of data to back it up. So it'll be up to, I think, engineering staff to calculate excess emission. But we can get to when we discuss excess emission. So during the period, the various, in effect, there are conditions in the various condition that look at monitoring for both leaks and odor surveillance, and also doing a 1173 sniffer test, basically one time after the adjustments have been made with the compressor, so that, and the daily ongoing pressure monitoring will be critical in making sure that that they stay within the limits. Or there are no excess emissions, basically, to the extent possible.
Thank you. Anyone else have any thoughts on the findings? Senator.
It's certain things are not clear to me yet. On Exhibit 9, I'm not opening it, I'm just discussing it. Number 5, 10, 17, 19. It says Signal Hills stopped taking S&C produced gas. Correct? That's what I think it said. And then you go on where it says, in that same page on 9:15 says that S&C participated in a conference call with Signal Hill Petroleum and other neighboring producers who had relied on Signal Hill vapor recovery system turbine. You're going to talk about, because of the weekend was occurring, you could still avoid a shut-in. Now, which one of these dates are correct? Did they stop accepting gas on the 10, 17, 19? And they were accepting it again on 11, 20, 19 or not?
Are you asking a question? Because we did close the,
I know, but
did you want to reopen?
to answer that question, yes.
I'd be
Okay, I
happy
think it's
to.
been answered, but I'll be willing just for that. And another member? Okay, we'll reopen just for that, for the answer to that question.
Okay. Initially, they had set a limit of 1,500 BTUs on the gas. They allowed people back into the system, and they went around and tested all the sites for the BTU content, and they were determining where the higher BTU content was coming from. So we were shut in initially, then we had a couple days where we were running again, and they tested the gas, and then they came back and shut everybody down again. So there were kind of two instances that we were not operating, and then operating for a brief period, and then shut in again.
Okay, but in testimony, you're saying Signal Hill is shut down permanent now?
We are now, yes.
Okay, thank you.
Wait, Signal Hill is not shut down.
Patrol,
Your-
as it relates to S&C.
Yes.
The leases that send gas to Signal Hill are no longer allowed to send gas to Signal Hill, according to Signal Hill, correct?
That is correct. yes.
Correct, right. I'm sorry.
That's okay, I just want to be very clear for the
We are
record.
physically disconnected from the pipeline.
No further business.
Okay,
Thank
thank
you.
you.
For the question.
And I think it was a good point to bring up that, just so we have it on the record, we did have a split decision with regard to whether or not you had come to us, or the petitioner had come to us quickly enough for the interim, but that's not really an issue here. Here, we're really looking at the 30 to 40 years when we're talking about beyond reasonable control, with which there was a reliance on Signal Hill taking and destroying and recovering the vapors. So with that, I think I agree 100% that beyond reasonable control can be found. Yes, Ms. Verdugo
Madam
Peralta.
Chair, since you opened it up, I have just one question, maybe it's more of a clarification.
Oh,
Because,
okay.
can I
Yeah.
ask that?
Yes,
Since we opened it?
and then we're going to close.
Okay. You had mentioned the 1 megawatt per day requirement from the PUC. Now, was that because they contacted you, or is it because you are going to be contacting them?
This is something I said,
Yes.
and
Which
it's
we had not
something,
discussed.
it's something that I've known because of working on the district's current technology assessment of beneficial uses for flare, for produced gas, which is following on to the adoption of the amendments to non-refinery flare rule 1118.1. And there are people in our industry that have worked for decades to try to allow smaller facilities, perhaps larger than the facilities we're talking about, the 2 and 3 well facilities, but relatively small facilities, to generate electricity and get it onto the grid.
Right.
There is no technical impediment of which I'm aware, because people generate electricity on their rooftops in relatively small quantities and get it onto the grid. So this is all part of discussion of things like the World Bank's initiative for zero routine flaring by 2030. But that's why I happen to know that, that's all.
Well, I do too, and so my question then became, once you mentioned that, the fact that since you're going to be putting it into the grid, you're going to be getting back, maybe not at the same rate as what you are paying per kilowatt hour, but that is still an amount that you're going to be getting back, correct?
Are we beyond the scope of the variance request here? Because what they do for a permanent fix is not before us today. Really, we're looking to see whether we are granting a variance for breathing losses because the facility is shut in until the permanent vapor recovery systems can be sorted out and put into place.
I understand that, however, and maybe this goes into our second discussion of fees, because that's a monetary amount, monetary value.
Well, we're not able to access the grid or generate electricity from which we would get fees back from the utilities.
So you're not going to do that?
They wouldn't be able to do
believe-
it during the pendency of the variance, which is the relevant period.
Right. I believe that one of the vendors that Mr. Williams has approached will thoroughly evaluate the potential for use of microturbines. And he's indicating that that is the case, and that would be Clean Energy Solutions. But I don't see any money back from the utilities for that level of electricity generation. It has to be at least 1 megawatt per day, and that's, I guess, the small microturbines, to my knowledge, are 300 kilowatts per day. And that's only less than 1/3 of a megawatt.
Potentially.
Yeah. But very interesting in the larger, and I'd be happy to talk with you off the record about that.
But I'm just wanting to fit it all into how this is going to work for your facility. And like I said, it may be our second discussion on fees because it is a reduction of your total output if you potentially do that. Depends on whether you do or you don't.
There's no potential from 2 or 3 wells to generate sufficient electricity to access the grid.
Okay, I wanted a definite answer.
That's
Thank
what
you.
you were looking for, and I gave you a little speech about everything.
Thank you.
Okay, any other questions before I close again? Okay, thank you. Okay, so we were discussing the 6 findings as presented, I think very well by Mr. Balagopalan. We'll discuss fees as a separate motion. Is there any other discussion on those 6 findings that anyone wants to add? Okay. Mr. Duca-Peralta, did you?
Thank you, Madam Chair. I just wanted to say that Mr. Balakopalan, I think, said it very well. I'm getting mess up here. I'm sorry. I can never say it correctly. Mohan. In any case, I think he put it very correctly, and the way that we're looking at it and the way that this is going to roll out, I'm hoping that everything will be adhered to within the proposed regular variance conditions. I have every confidence that it will be. I see your earnest here, the fact that you came before us and have been trying to be ahead of what situation you've fallen into, unfortunately. But I'm glad that you did, and so we can help you out as well as you can go forward with this. And the whole thing is about reducing emissions and not having excess emissions, and I think you've done a good job on that. So I am in favor of this and feel that the 6 findings have been met. Thank you.
Mr. Balagopalan, do you wish to make a motion? Oh, sorry, Senator, did you have more to add?
Maybe I should speak after the motion, but on December the 5th, we heard this matter. Then was then and now is now. And I think I was one of the no votes. Is it appropriate to say why I voted no then?
If you'd like to, but I think it's a very different.
I understand. I'm going to say then was then and now is now.
Right, and I would agree.
Okay, so at that point in time, the information was not clear. There was no evidence. The district was not even supportive of the interim variance. And the progress you've made since then gives me a different point of view as relates to your request. And I just asked some recent questions regarding when they stopped taking gases from you, from my own information. And I take notice that on November the 15th, when you were again notified, after they were supposed to have stopped taking it 10/17, but November 15th, over the weekend, they said, no more. And I think from that point going forward, they were not accepting any more of your petroleum. Okay, fine. So that makes it clear to me today as compared to what, and December the 5th. So I would say that you've gotten some additional information. You have a stipulated agreement on the conditions as modified. That being the case, the district is satisfied, and so am I. And I would so vote.
Thank you.
Thank you, and we'll get to that once there's a motion. Any other thoughts on the findings before we move to a motion? Okay. Mr. Balagopalan, did you wish to make a motion? I could, or I can make it if you, whichever you prefer. Yes, go ahead.
Okay. In the matter of SNC Oil Company, Inc., case number 6165-1, I move that we grant a regular variance commencing today, January 8th, 2020, and continuing through, I think it's 10 months, so
I think we calculated to be November 8th,
November 8th.
which is 10 months, or final compliance, whichever occurs first, I think.
From the rules and subsection that actually been identified in Table 8 for this individual leases. And I would just want to add that this case includes 3 different locations, 3 different leases, and so there, and I'll just mention, so it's the 2 specifically that are not, it's the poly lease ID number 64093 located Northwest 25th and Gundry in Long Beach, the Barnes Bush lease ID number 122974 at Atlantic and 29th in Long Beach, and also the Whitney Barnes lease ID number 45882 at 2676 Orange Avenue, Signal Hill. 2 of the leases, Poly and Barnes Bush, are not producing, but the Whitney Barnes is producing. So that's where the equipment is located in the city. So, and the conditions that are as set forth in Exhibit C, with the addition of condition number, revised condition number 4, and we have to renumber the other conditions accordingly. And do I need to read 4?
I think that the Madam Clerk has condition 4, is that correct? Okay, so I don't think you need to reread it.
Renumbered, correct, accordingly. And let's see. And then I know we were going to discuss the excess emission fees, so
We can, if you don't mind, we can add in, well, I'll second that motion. And then we can add into what was condition 12, the date of 15 days from now, because there will be fees. And we'll take up the matter of how much those fees will be. And then finally, the excess emissions are anticipated.
yeah, the excess emission as provided Mr. Laney, and I've written down.
I have them if you want.
Okay.
For the poly lease, it's anticipated to be 3.3 pounds per day of VOC and 0.1 pounds per day of benzene. For the Bush Barnes, 6 pounds per day VOC, 0.1 pound per day benzene. And for Whitney Barnes, no excess emissions are anticipated. And it is to be determined because there will be hopefully some reduction based on the interim measures they'll be taking.
Correct, and I just wanted to add that there's a conservative estimate, and since we're in the winter season, so the breathing loss, the temperature is not that high, so the losses could be lower than what was provided here. And with the addition of the compressor and the piping for the gas, the emissions should be further reduced.
Thank you. So I have seconded the motion. I just want to also be very clear. I think you mentioned this, but all of the rules that apply to each of the leases and where their locations are and what the equipment is very clearly set out on Exhibit 8. So your motion is based on that, correct? Okay. So the motion has been made and seconded. Any discussion on the motion?
As I said earlier on, that in December 5th, it's not very clear at that time. Since then, you provided a roadmap concluding the dates and the activity that you've taken. It's kind of conflicting. That's why I asked additional questions. However, notwithstanding that, since you stipulated to the conditions set forth by the district, it gives me an opportunity to say, okay, go for it, going forward. And you have reporting dates and time as to whether or not you have to, you're going to meet those conditions. You're locked in. That being the case, I can give you an aye vote.
Okay, so you vote yes? Okay. Dr. Bernstein, how do you vote? Aye. Ms. Verdugo-Peralta, how do you vote?
Aye.
I vote yes. Mr. Balagopalan?
Yes.
Okay, motion passes 5-0, so the regular variance has been granted. Now we need to take up the next question, which is a request by petitioner to adjust the excess emission fees, and it is made pursuant to Rule 303G, and I'll just read it. Adjustment of excess emission fees. The hearing board may adjust the excess emission fee required by subdivisions D, E, and F of this rule at the request of the petitioner or upon motion of the hearing board based on evidence regarding emissions presented at the time of the hearing. So that is the basis for the request, and that is the basis on which we will consider it. And the request was to reduce the, to stepping back, fees are based on two possibilities. One is actual emissions, and if those are less than the minimum daily amount, it will be based on the minimum daily amount. And in this case, my understanding is the request is to reduce the minimum daily amount from $199 to $49.77. I just want to make sure I'm getting that correct. Is that correct?
That is correct.
Okay, so it's about a quarter of the, so it's reducing it by about 75%. That is the request. So open to thoughts and discussions on that. Mr. Balagopalan, if you'd like to start it.
I do have some hesitancy doing that because it's based on the evidence provided. Mr. Tether did say a 75% reduction. There's no supporting evidence to show that there will be a 75% reduction with the addition of the compressor unit and the routing of the pipe. So I think even the emissions that were estimated by using the tank form has to be verified by, the engineering staff. And so I would have hesitancy in, I would not support the motion to reduce the minimum fee that they need to pay.
And I definitely hear what you're saying because 303G is based on evidence regarding emissions that were presented at the time of the hearing, and we did not necessarily have that specific evidence that you're talking about. One possibility is to not grant the motion at this time and allow for some kind of limited return to the hearing board once the system is put in place and there is that 1173 monitoring, and there can be evidence presented that in fact the emissions are greatly reduced, and at that point we can reconsider the adjustment. We could also put off the payment of fees. We had said 15
days.
Did we put that in? Yes, okay. We had said 15 days. We could make a motion now to amend that and have the payment of fees not due until that monitoring is completed, and then a return if they wish to request a reduction at that time. It would have to amend just for the date of which the, I think we could do that by this motion. I think we could do that. It's not substantively changing anything about the variance itself, other than when the fees are due, so that we could account for this. We already voted. We already voted, but we could do it by this motion. Ms. Verdugo-Peralta, you had some thoughts?
Thank you, Madam Chair. I'm much more comfortable doing that based on the fact that we would be looking at the fees based on actual evidence, as well as holding back the payment so that the petitioner is also aware of what that is going to look like.
Other thoughts? Dr. Bernstein?
Madam Chair, I think that you summed it up appropriately. Whatever fees are paid should be based upon evidence, and we should give appropriate time frame for that evidence to be presented, and then levy those fees accordingly.
Okay, and we had a time frame in the new condition that was added to now what are the conditions of the variance, that Rule 1173 inspection will be conducted, what was the date? Within 7 days of installation.
Which would be January 29th or perhaps sooner.
Okay, so if we were to, we could have a motion to return to the board 7 days after the 29th, which, or somewhat, that makes sense? We'll
Could that
look
be
at the-
done by declaration in a consent calendar format? We could certainly appear in.
I'm not
person.
sure what the position of the district would be. I don't know if you tend to stipulate as to requests for fee reductions.
We typically don't take a position on that, but I don't see why we couldn't stipulate to having it heard on consent.
Because there would have to be agreement as to what it is you're proposing. Because if it's on consent and the parties are not here, we would have to either take it or leave it. And so I think there would have to be agreement of the executive officer for whatever the request is.
Over, 200 days.
I'll have to.
I was thinking about that as well.
Yeah, I'll have to consult. I know typically the position is we don't take a position, but I'll have to check with.
Well, first
the
of all,
office.
let me just go off the record for a minute, just to get the red, could we get the red book? Thank you. Actually, we don't have to go off the record, but if the clerk could get that, and we could look and see what the dates would be. It would be,
Well, that's true. We're on calendar for February 5th.
Oh,
oh,
Yeah, for the other.
that is true.
That's right.
Thank you.
Okay,
Doug.
so February 5th it would be. Now that I sent the clerk. She likes to get up and exercise
And
anyway.
I was going to say, I would be more comfortable if the district staff had the opportunity to review what their estimate, their calculations, so forth, and agree to it before we,
Okay, so I sent you out, and
Well-
they're coming back on the 5th, so we're going to make it the 5th. For adjustment of fees, even if we're continuing that?
If you're continuing it
We're gonna
as part of the hearing, but if they're coming back specifically
You're right.
for fee waiver, and you're circumventing the fee waiver notice.
It's not a fee waiver, it's an adjustment. Is that the same thing?
It is.
Okay. No, it is not, or it is?
Yeah, I don't believe it is.
Oh, it is not. Okay, but, shoot.
I can check and make sure that I'm not.
you just said 10 days, right?
It's a 10-day posted notice, which for
Yeah, that should be enough, though. It's a month away, right? February 5th, yeah, yeah.
Okay, okay. So we'll have that checked, and in the meantime, my thoughts would be, by motion right now, we will amend or pause, or however we want to say it, condition, what is now condition 13 with regard to the applicable fees being due in 15 days, and instead make it due February 5th. And at that time, we will also continue the request for a fee waiver to be heard on that day. Not fee waiver, but a fee reduction adjustment.
I'm trying to think of the timing of getting the payment. In other words, would we need to be bringing the payment for the worst case on the 5th?
That's true.
Or maybe just provide another few days?
Let's make it,
Fee adjustment, you may or may not, consider it for fee adjustment.
yeah, no, we are. We're just wondering when the fees would be due. We can make it February 10th, good?
Yeah, let's see, Thursday, Friday, Saturday, yes.
Okay.
Does that sound good?
Okay, so the first thing I'm going to do is ask,
The 10th is a Monday.
I'm sorry.
11th?
Okay, so then the 11th.
Just wanted to.
Thank you for that. Okay, so this is what I'm going to, unless there's any other thoughts, I'm going to first start with a motion to, I'll say amend. I'm going to move to amend condition 13 of the regular variance simply in the following way. The amendment would be to change the date by which applicable fees are due from 15 days, which it currently states, to be due on February 11th, 2020. Is there a second for that? Second. Okay, Dr. Bernstein seconds that. Is there any discussion on that motion? Ms. Verdugo-Peralta, how do you vote on that?
Aye.
Mr. Balagopalan?
Yes.
Senator, how do you vote on that? Okay, and Dr. Bernstein? And I vote yes. Okay, so motion passes 5-0, just to delay the payment of the fees until we have an answer on this. The second thing I would like to move on is that we continue the request for,
Revoke that motion, included a motion, you should state it supersedes the item that we introduced the 13th.
yes,
The date supersedes that date.
okay. Okay, but just to be clear on the motion, it was to supersede the date of 15 days from now, whatever date that is, and supersede it with the date of February 13th. Does everyone still agree with the vote that they made?
Yes.
Okay, okay, thank you. Okay, moving on to the second, I'm going to move that we continue the request for a fee adjustment under 303G, Rule 303G. We continue that to February 5th, 2020. Is there a second for that?
I'll second that.
Okay, Ms. Verdugo-Peralta seconds that. Any discussion on that motion? Okay, Senator, how do you vote? Okay, Dr. Bernstein?
Yes.
Ms. Balagopalan? I vote, sorry, Ms. Verdugo-Peralta, you vote?
Aye.
And I vote yes, motion passes 5-0. Okay, so where we stand, just to sum it all up, the regular variance has been granted. The date of 15 days for the payment of applicable fees has by motion been superseded. They will now be due on February 11th, 2020. And we have continued the motion and request, well, we've continued the request by petitioner for a fee adjustment under 303G to February 5th when another matter is being heard that is related. And that sums it all up. Thank you very much. Okay, any other business board members before we adjourn? Okay, we are adjourned. Thank you.
Thank you all for your time.
Oh, he wants to give you something for your cold. It's really good stuff. It's like one of those herbally things.
I have heard of that one.
Oh, that, yeah, because